Here was the list of orders that came down, and you'll notice a bunch of cases got denied, but not this one. Boom. 24568, Michael Bost et al. Versus Illinois Board of Elections. Because in the court's opinion, they did not need to conduct post-election monitoring of late arriving ballots in 2022, and thus any expenses were self-inflicted. Okay, that's rich. It's rush, it's high stakes, low information decisions. It's a disaster because there's deadlines coming up. They all have to make their decisions before like the clock ticks out. The Supreme Court decided to hear an election case, this one involving ballots that come in after election day. Very interesting issue. We thought that kind of had an election day so that you could get all the votes in, count them, and declare a winner, and everybody would go home and know that we had safe and secure elections. But Democrats don't like that game because oftentimes there's a deficit there and they need to close that gap, just like we saw back in 2020 when those charts went all like this. We all went to bed and then we woke up bloop, bloop, and the charts were all different after 2020. Well, now the Supreme Court is going to hear the challenge to an Illinois mail-in ballot law. New York Times has some background on this. Then we'll go into the actual filing that was submitted to the Supreme Court. They accepted, so we can get some background on what is coming up. But the New York Times gives us some background here, saying that they announced Monday that this lawsuit brought by conservative congressmen will be heard. And it's challenging an Illinois election law that allows mail-in ballots to be counted up to 14 days after an election. So 2 weeks, the election date is over, and they want to close the gap on that and do that F thing that we saw in the charts. And so they just go get them. Call all their absentee friends, whatever. It's like Arizona, I think, was like 14 days. Remember that? They made fun of us, still making fun of us. Rightfully so. And now they want to codify that so that no matter what happens, you can get your ballots in if you really need to. Get a few of them in too if you want. Representative Mike Bost is a Republican who represents a district in downstate Illinois, along with 2 federal electors. He sued back in 2022 saying you're violating federal law. You can't allow absentee ballots to be received and counted after the election, and all those absentee ballots, we know which way those go. Republicans have repeatedly challenged these, saying Trump lost in 2022 because mail-in balloting was expanded back during the pandemic. Remember all those ridiculous lawsuits we covered back then? A federal trial court had dismissed the case. They said no standing. Isn't that interesting? So if you're an illegal alien and you sue to challenge your deportation, judges will issue classes of illegal aliens, status, lawyers, due process rights, multiple hearings, all these things, like due process premium. They already had due process rights, but due process premium, where they get extra hearings, free lawyers, red carpets, all the things. But if you sue because your government is illegally breaking the federal law, no standing, go home, get out. We want illegal. Maybe that's part of the process. They want those illegals to vote as well. That's the process. So maybe absentee. Now, a federal appeals court agreed and said Mr. Bost, who's represented by Judicial Watch, shout out to Tom Fitton, asked the justices to weigh in. So the election law dispute is one of a bunch of cases the Supreme Court was considering. Here was the list of orders that came down, and you'll notice a bunch of cases got denied, but not this one. Boom. 24568, Michael Bost et al. Versus Illinois Board of Elections. And so the Supreme Court will be hearing this case. Here is what they sent in, and the question is a good one. Supreme Court, can you help us figure this out? You know, federal law sets the first Tuesday after the first Monday in November as the federal election day. It's in the U.S. Code. Several states, including Illinois, have enacted state laws that allow ballots to be received and counted after election day. Now, we contend that these state laws are preempted under the Elections and Electors Clause. Petitioners sued to stop Illinois from allowing ballots to be received up to 14 days after election day. Cheaters, man. The sole question presented here is whether petitioners as federal candidates have pleaded sufficient factual allegations to show standing. Can we at least be heard like an illegal alien in this court, please? Or like elected officials? Can you hear our case, please? Can we challenge this, the time, place, and manner of the elections because they're breaking federal law, Supreme Court? We'll see what Amy Coney Barrett says. Of course, they accepted it, so we'll see what she says ultimately. But we got the parties to the proceeding. So we got these people. We got a U.S. congressman, right, called Michael J. Bost, and Republican presidential elector nominees suing Illinois State Board of Elections. They sent this writing. All right, Supreme Court, we're knocking on your door and trying to get your help on this because here's what's going on. For over 130 years, this court has heard claims brought by federal candidates challenging state time, place, or manner of elections. Now, until recently, it was axiomatic that candidates had standing to challenge challenge these regulations. That I'm running in that election. This election is going to count votes for 2 weeks after the election is over. I have a problem with that because I think that I will lose or whatever. Now, indeed, it's hard to imagine anyone who has a more particularized injury, somebody who's actually involved in the candidate who's on the ballot. Now, that is because a candidate who pours money and sweat into the campaign, who spends time away from her job to do all of this, has an interest in the lawfulness of the election. And it's not just some random voter who is suing. And we have this other concept in standing, which we talk about, which is this idea of a political question. And the thesis on that is that you can't just sue your government because you're unhappy with the functioning of the government. If it's a political question, go vote, go run for office, go raise money. This is America, right? Go scream at your friends, go be like Tim Walz and bully somebody or whatever. Don't do that. Now, in the aftermath of 2020, which we covered at length, we did dozens of lawsuits here. However, for a variety of reasons, courts have limited candidates' ability to challenge the electoral rules governing their campaigns. Yes, because it's rigged. Now, this case presents the latest and an extreme example of this trend. So they change the rules, candidates sue, they say you can't sue, and the changes happen. And then who sues? No one. Voters sue, no standing. We saw all of this during 2020. Like 90% of our cases were kicked out on some stupid excuse of standing. Petitioners were saying, who can sue then? We saw electors sue, we saw candidates sue, we saw voters sue, we saw like party leaders sue, presidential electors sue, secretaries sue, states sue, no standing. So who can sue? Nobody, because the courts get to decide who wins elections based on these findings. Now, petitioners are a sitting multi-term congressman and 2 federal electors. They challenged an Illinois law, which is this receipt deadline law, that allows absentee ballots to be received and counted after the day specified in federal law, which is known as Election Day. Now, they contend that Illinois' receipt deadline is preempted by the federal Election Day statutes. They asserted Article 3 standing on a number of grounds, including that they incur costs to run their campaigns and more, and they claimed a particular interest. Now, a divided panel of the 7th Circuit affirmed the lower level court's dismissal. They said, no, it's not enough standing. The majority said that the congressmen and the electors had not pleaded an injury in fact because in the court's opinion, they did not need to conduct post-election monitoring of late arriving ballots in 2022, and thus any expenses were self-inflicted. Okay, that's rich. The court also declined to find standing because the 2024 election was, back then, 2 months away. So rich, man. And they did this too last time in 2020. No, the election hasn't happened yet. There's no fraud. Well, there's going to be fraud because they changed the law. Like they changed the election manual. The law says they have to do it this way, but they just published the manual for the election on how they're going to operate it. And it says it's illegal. Like it's illegal to the law. And so, well, you haven't seen that it's going to be illegal yet. The election hasn't happened. So no standing. This case is not ripe enough. It's got to ripen up. Then after it's over, you sue. They find another reason why there's no standing. Might be mootness. Now, well, it's already over now. And so now there's nothing we can do about it. And you should have raised that objection before the election like we did in like 50 lawsuits. But you didn't have standing for those. So it's like a back and forth, right? It's a cat and mouse game and whatever happens, they win. Now, until this ruling, because when you control the rule keeper, when you control the referee, you can win the game. Until this ruling, the only non-vacated circuit authorities to confront the question of candidate standing had held that candidates do have standing to contest violations of federal election law that actually impact their campaigns. And so we, the Congress people now, respectfully submit to the Supreme Court, which accepted this, that it is important for the court to correct the serious errors of this 7th Circuit, especially those that are fostering an arbitrary approach to jurisdictional issues when federal candidates sue. It's also important that lower courts and potential litigants know, and the public know, that federal courts are open to hear timely, well-pleaded challenges to state time, place, and manner regulations on elections. Federal court rulings on the merits, regardless of the outcome, promote public confidence that federal elections are being conducted fairly, with integrity, and in accordance with the law. Now, Congress is authorized, they say, under the Constitution to manage time, place, and elections. Now, Congress exercised that power when it enacted Election Day statutes back in 1845. And in fact, in 2022, we added even new things. But prior to 2005, let's go to Illinois. The law required that absentee ballots must be postmarked the day preceding Election Day and received by state election officials on or before Election Day. Okay, that was the law. So then in 2005, the receipt deadline was amended, saying that ballots received after the polls close on Election Day, but before the close of the period for the counting of the provisional ballots can be counted. Okay, so provisionals, these get extended to the provisional deadline. These ballots need only be postmarked on or before the Election Day. If they bear no postmark, then they got to certify within a time frame. So then election officials appeals are directed to validate. Now, reading all this together, it means they've got up to 14 days to count their ballots, saying 14 days, right? So that's what the law says. So then in 2013, Illinois adopted a statewide vote by mail practice, which expanded the category of acceptable absentee ballots. So then the Congress people sued. Multi-term incumbent representing Illinois. This other person is a director, and their complaint sets forth 3 claims. Constitutional violations, saying the receipt deadline injures them as federal candidates, in violation of their First and 14th Amendment, infringing their right to vote, and third, it violates their federal statutory rights under the law. They sued in May 2022, long time ago. Bunch of motions. 2023, the motion to dismiss filed by Illinois, the government granted. So they win and the Congress people lose. Then they appeal, went up to the 7th Circuit, sharply divided, 2-1 majority, said, nope, you don't have any actual injuries, so you can't sue. They reached that conclusion. They said late arriving ballots in 2022 were unlikely to cause the congressman a defeat because he won so big. He's like, well, who cares if they were fraudulent? You won. So since you won, there's no harm. To reach this conclusion, the panel took judicial notice that 6 months after they filed suit, he won by a large margin. They say you won, so there's no injury. Ultimately, the panel concluded it was speculative at best that late arriving ballots would cause him to lose. So since the fraud didn't happen here to you, no harm. The panel did not describe how in pre-election lawsuits anyone can determine whether this is a case or not. Panel didn't address that, just said, well, there's no injury here, and we can't really tell you how to tell if there's going to be an injury in the future, but you can't sue now. That's what we can tell you. Well, when can I sue? Well, we don't know. We'll have to see it before we can tell you. The panel distinguished seemingly binding precedent that recognized their injury and said, well, those cases are different, but we do have injuries, and the panel held against them. Now, as we go up to the Supreme Court, they say, you guys got to hear this case now, SCOTUS. The lower level court, the 7th Circuit, it said Congress people don't even have standing to sue. They made their ruling notwithstanding undisputed testimony that they would expend resources and additional campaign expenses on those additional 14 days. Like, the campaign's not over. You got to get out there and continue to campaign. But the ability to sue has been narrowed again. So now even a congressman can't sue before? This is a very recent trend. They say for over 130 years, this court has heard claims brought by federal candidates challenging elections. Here's a bunch of them. You've got McPherson, Bush versus Gore, Bush versus Palm Beach City, New York State Board of Elections, a bunch of them. Now, the panel and the dissent, however, illustrate how lower courts have struggled with this new question of candidate standing. These cases involve truncated proceedings with expedited briefing, little opportunity for adversarial testing of evidence. It's rushed, it's high stakes, low information decisions. It's a disaster because there's deadlines coming up. They all have to make their decisions before the clock ticks out. Pleadings are passionate and urgent. Now, in consequence, as many a scholarly review of the period concluded, courts took a very strict view of standing, and unmeritorious challenges and a desire for orderly electoral processes may have resulted in courts too cavalierly dismissing legitimate claims of standing, confusing standing questions with merits questions or both. They were not going to allow Bush versus Gore to happen again or something in 2020. Just not going to let it happen. All the judges, all the attorneys. And so this reached 3 circuit courts of appeals in 2020. The 7th and the 8th circuits both ruled that federal candidates do have standing. Final circuit to continue that question said did not have standing. This court never reviewed that case, and so we need you to do that now. Now, though vacated, that other case is still permeating the lower court rulings, but it's been misapplied. This court's decision in Lance has been misread in a number of cases following 2020, and so you guys need to fix this. Saying the court's guidance is needed to correct the unwarranted narrowing of our ability to sue, and Supreme Court, you got to hear this. If you don't allow us to sue, it's going to implicate and cause tangible injuries, and this alone allows you to intervene. There is much more than a broad interest here. We've got actual concerns about the upcoming elections. Now, the panel noted that this congressman's allegations that after he lost, or after the election, he was going to monitor the counting of the votes, and the court below said, well, that's not enough of a harm. And we say it is a real cost, right? In order to run an election, you actually have to be able to run an election. We got to dive into politics, Rasmussen, Cook Report, bunch of other things, and there's a bunch of practical issues too. And we can't sue when the election is months away because it's too speculative, but then if it is 2 months away, then it's too impractical. It's like, well, it's too far away, and then the election's coming up, and it's too soon to sue. So that's what they're doing. We sued. We've been suing all over the place. We've sued many times, okay? We filed a lawsuit well before 2022 and 2024. Rather than instituting emergency or expedited procedures, we pursued their claims through a pre-election challenge. But if courts use that against us, saying, okay, we sued before, we're suing after, we can't sue anytime, this is a bad incentive. It means we have no standing at all. And so you got to allow us to challenge these things. We have. have. We're showing you we've suffered an injury. It's going to be imminent. It was caused by them, and you can redress this. This congressman was first elected to represent the House 12 years ago, and he has seen the changes. He said it's significantly more difficult to find volunteers to work after Election Day, and all the expenses are gone. It costs time and money, and it's out of compliance with the law. He also alleged competitive injuries based on a prospect that illegal votes could diminish the margin of victory. He said, this will lead to the public perception that my constituents have concerns about my job performance and more. And so the panel made a mistake when they denied this claim. They said that there was no legal basis for us having standing, but there is, as you can see. There's at least a basis, but they didn't want to hear it. So finally, the panel erred by ignoring you, Supreme Court. That case involved Senator Ted Cruz in a campaign finance regulation when he made personal loans to his campaign, whether he knowingly triggered it and more. But the decision below is creating a split. And so we need you to come in here and settle this for us. So do we have standing to sue? Yes or no? And I think the Supreme Court is going to lean back towards yes, right? If they were happy with the lower level ruling of the Seventh Circuit, they would have just denied cert and said, yeah, no standing here. But this case is the ideal vehicle, and they've been on this for a while. It arises out of a motion to dismiss. It's limited to this one particular issue. There's no lengthy factual record. We've got a bunch of different questions to come up here, and it's time to settle this. Signed and submitted by Judicial Watch, Robert D. Popper, Eric Lee, and T. Russell Nobill, counsel of record for Judicial Watch, sending that in to the United States Supreme Court. And of course, the Supreme Court has now granted that. And we're excited to see where this one goes, because we followed dozens of lawsuits in 2020, and those lawsuits were all largely dismissed, denied because of these issues. No one could sue anywhere. And they claimed victory, but we never got to the merits. And now, hopefully, the Supreme Court gives us that opportunity by allowing these lawsuits to proceed. And both sides will be suing, but I'm fine with that. Democrats want to sue because they think they lost an election. Let's go ahead and peer into those Pandora's boxes over there. We want to see how all the elections are operated and see what's happening mechanically. Now, the Democrats are not suing generally for those issues, right? They're not suing to say, well, we think that there was some fraud or something. They're suing to change the rules. So we got to distinguish those two. They sue a blue attorney general, enter a settlement agreement, judges accept it. The whole election is changed because they rigged the code. That's not what we're looking forward to. We want to see what's happening in the guts of these elections, where we have blue secretaries of state like Katie Hobbs, who suddenly then comes in and wins in Arizona when she can't hardly put together a sentence. So we'll keep our eye on this one. Good news out of the Supreme Court. They are accepting this case. Boss versus Illinois Board of Elections. We'll keep our eye on it. Thank you for subscribing and joining as we do.